What is a waiver? A waiver is the relinquishment or refusal to accept of a right. In practice, it is required of everyone to take advantage of his rights at a proper time, and neglecting to do so will be considered as a waiver. If, for example, a defendant who has been misnamed in the writ and declaration pleads over, he cannot afterwards take advantage of the error by pleading in abatement, for his plea amounts to a waiver. In seeking for a remedy, the party injured may, in some instances, waive a part of his right and sue for another. For example, when the defendant has committed a trespass on the property of the plaintiff by taking it away, and afterwards he sells it, the injured party may waive the trespass and bring an action of assumptions for the recovery of the money thus received by the defendant. In contracts, if after knowledge of a supposed fraud, surprise, or mistake, a party performs the agreement in part, he will be considered as having waived the objection. When a constitutional provision is designed for the protection solely of the property rights of the citizen, it is competent for him to waive the protection and to consent to such action as would be invalid if taken against his will. In criminal cases, this doctrine must be true only to a very limited extent. In capital cases, the accused stands upon his rights and waives nothing. The weight of authority on his subject is with the doctrine that in prosecutions of crimes, at least when the crime charged is other than mere misdemeanor, the defendant cannot waive his right to trial by jury of 12 men. It is a rule of the civil law, consonant with reason, that anyone may renounce or waive that which has been established in his favor.